Broadcasting live from the Newsmax studio in New York City, here is Steve Malzberg.
So these health insurance exchanges, once again, you go on mahealthconnector.org and see ours in Massachusetts, will be these new shopping places, and they'll be the place that people go to get their subsidies for health insurance. In the law, it says if the states don't provide them, the federal backstop will. The federal government has been sort of slow in putting out its backstop, I think partly because they want to sort of squeeze the states to do it. I think what's important to remember politically about this is if you're a state and you don't set up an exchange, that means your citizens don't get their tax credits. But your citizens still pay the taxes that support this bill. So you're essentially saying to your citizens, you're going to pay all the taxes to help all the other states in the country. I hope that that's a blatant enough political reality that states will get their act together and realize there are billions of dollars at stake here in setting up these exchanges, and that they'll do it. But, you know, once again, the politics can get ugly around this.
All right, folks, that's Jonathan Gruber, economist at MIT, one of the so-called architects of Obamacare, telling the folks there that Congress intentionally wrote the ACA so that people in the states that didn't set up exchanges would not get credits and subsidies. Joining us now is the Attorney General for the state of Oklahoma, Scott Pruitt. Mr. Attorney General, welcome, sir.
Hello, Steve. How are you?
I am fine. So as the state that was the first to sue over this issue, what's your take on one of the architects of Obamacare basically making your case for you?
Well, when you think about the video clip that you just showed, there was actually an audio clip that was also discovered last week. Both of those clips are in direct opposite of what the Justice Department has argued in our case. In our case, the Justice Department argued that, of course, Congress and, of course, the ACA intended that in all 50 states, irrespective of whether there was an exchange set up or not, that the tax credits would issue. And here you have the architect, Jonathan Gruber, retained by the White House to advise Congress, was involved in the construction of the ACA at those very minute levels, saying unapologetically, unequivocally in 2012 that if the states didn't get on board, as he said, they would be penalized. Their citizens would not receive the tax credit. So it is exactly what we've been arguing. It is a confirmation of what we've argued from day one about the fact that Oklahoma, along with 33 other states, have said no to an exchange, and there are consequences to that, meaning that if there's no exchange, there are no subsidies or tax credits, and therefore no penalties that can be assessed against those corporations and companies that don't provide the necessary insurance that is required in the ACA. So it's a hugely important matter. We actually filed a motion yesterday, Steve, with the court in Muskogee, Oklahoma, and the Eastern District of Oklahoma, making them aware of the clip that you just showed, but also the audio clip as well.
So last week when we had the two conflicting decisions by the courts, the D.C. Court of Appeals ruled in your favor, so to speak, and it was the Fourth Circuit that basically, and I'm no lawyer, but kind of said and took liberty with their interpretation of how the law was intended as opposed to what it said. Am I correct?
You are, but you know what's interesting about the D.C. decision and the Halbig versus Burwell decision is that the court there looked at the plain, unambiguous language of the statute and came to the conclusion that clearly the IRS could not do what they did. But they went one step further. They said, you know, the government wants us to look at legislative history, so we will do that. And they then went into an analysis with respect to legislative history and said, even if we do that, we come to the same conclusion, that Congress intended for the subsidies, the tax credits, to be issued only through a state exchange. And Steve, there's a really important reason why why it was structured that way. Congress wanted the states to be involved in the distribution of health care. They wanted a partnership with the states. They could not require or mandate the states to do that. That would be a commandeering claim. That would violate the Constitution otherwise. And so they did what Congress always does. They incentivized the states with money. And the money that they appropriated through these subsidies was exactly what the incentive was to the states to participate. When 34 states said no, the administration and HHS and the IRS had a problem. And then after the fact, in May of 2012, around the same time, by the way, that Jonathan Gruber is talking about these issues in the video and the audio that you showed, he says that the states will be penalized. He actually offers, as you saw, proof of what our position is with respect to what's wrong about the IRS rule.
Yeah. So when this goes, I assume you assume that it'll go to the Supreme Court, possibly even in the next time they gather. And I guess you're pretty confident in what they will rule. Although 5-4 decisions, you can't be too confident. Maybe, who knows? Maybe this would be a bigger decision.
Well, I'm not entirely sure that I'm an old baseball guy and played baseball in college and owned a minor league baseball team here
It ain't over
in
till
Oklahoma
it's
City.
over.
Yogi Berra once. Well, but Yogi Berra one time said predictions are pretty tough, particularly about the future. So if you come in and say we have confidence that one thing's going to happen over another, I think that's a little bit probably. I would not say that. I think what I would say to you is that the position that Oklahoma has taken from the very beginning, and we were the first state, we were the first one to go out and challenge the IRS rule. When we made this claim, at that time, people were saying that it was contrived, that it was political, that it was not about rule of law, that it was not about the statute and enforcement of the statute. I think we see here a year and a half later that our position has been affirmed by the very opponents of our lawsuit who were on tape at that time saying our position is exactly what they intended under the ACA. So we hope and are working toward an outcome that says that the IRS rule is unconstitutional and that our court will follow the D.C. Circuit.
And what would that mean for your state? I'm so caught up, and we're so caught up in the legal rulings and who wins and who loses in court. But what would that mean if the Supreme Court does uphold, say, yes, the D.C. court was right, the subsidies are illegal? What does that mean for the state of Oklahoma?
If the Supreme Court affirms the decision last week in the D.C. Circuit, if they affirm that, if they affirm Oklahoma's position that we've been maintaining, that means $700 billion of subsidies don't issue. The $700 billion of tax credits don't issue. It means that the IRS cannot enforce the statute with a $2,000 per employee penalty with businesses in 34 states. It affects the structure of the ACA in a substantial way. And the other side has actually used that to say, well, that's why we would never intended it. But the court does a great job at explaining that they in fact did that in other examples with the Class Act and the territories and taking certain things away and treating them differently under the law. What the How Big Court did, what the D.C. Circuit did, in my estimation, and they said this at the very end, they were reluctant to find what they found. They were reluctant to actually hold what they held because of the effect. But they said our job is to interpret, to give meaning to the laws as passed by Congress, that the statute is clear, it's unambiguous, and therefore we must enforce it as Congress passed it. If there is a problem with that, there is an answer. It's to go back to Congress and change it legislatively. It's not for an administrative agency to come in after the fact and unilaterally try to improve or fix the problem. That's not what administrative agencies do. They're there to administer the laws as passed by Congress. This statute is clear. The court recognized that in the D.C. Circuit. We hope that the same thing occurs here in Oklahoma and that the Supreme Court ultimately affirms that.
Well, we shall see what we shall see. I appreciate you coming on, but can you predict at least if you think this case will be expedited? Or will the government have they insisted?
See, I thought you were going to tell me. I thought you were going to ask me.
What? What?
I thought you were going to ask me about, predict if the Dodgers are going to make it to the World Series this year, or,
all right,
or something like that.
We'll say,
which I have.
We're about to lose our satellite connection, Mr. Attorney General, I am told. So if we do, I thank you. But let's keep talking and see if it does go out. Otherwise, I hope the Dodgers. You're a Dodger fan, I presume?
We have some Dodger connections.
Okay, there you go. All right, Attorney General Scott Pruitt from the great state of Oklahoma, thank you very much.
Thank you.
Take care. All right, folks, very interesting conversation. We played you that first bite of one of the architects of the Affordable Care Act or Obamacare, whatever you want to call it, however you want to identify it. We do have one other bite as well from Jonathan Gruber, MIT economist and architect, as I mentioned. But basically, it's really near the same thing as the first. So very interesting. That's going to be, I think, a key in the court case as well, presented as evidence when it does go to the U.S. Supreme Court. Okay, actually, let's play it. Let's hit 39. Let's hit 39.
Chris, it is unambiguous. This is a typo. Literally every single person involved in the crafting of this law has said that it's a typo, that they had no intention of excluding the federal states, and why would they? Look, the law says that people are only subject to the mandate if they can afford insurance, if it's less than 8% of their income. If you get rid of these subsidies, 99% of the people who would get subsidies can no longer afford insurance, so you destroy the mandate. Why would Congress set up the mandate and go through all that political battle to allow it to be destroyed? It's just simply a typo, and it's really criminal that this has even made it as far as it has. Chris,
All right, now, it's a shame we didn't play the two together because that's the same MIT guy. In the first bite, you heard what many people interpret as him saying, yeah, it's no typo. That's how it was written. Not saying it's no typo, but explaining exactly how it was written and what it meant to the letter of the law. And now he's coming on here and saying, no, it was a typo. So it seems that there are two contradictory statements. All right, folks, we're coming back with the one, the only, Gimme 5 on the Steve Malzberg Show.